Hi, my name is Claudia Fotiu, and this is my critical assignment for legal aspects of Kinesiology Kin 550. Facility background I've selected for my critical assignment is the athletic training facility, as I'm an athletic trainer. This is a setting that I work with most often. Risk management for this setting particularly is going to be the development and implementation of treatment protocols, ensuring that you have created appropriate policies for managing acute injuries, such as those that have to do with neurological or cardiac emergencies, and also developing emergency action plans that are tailored to specific venues. So your emergency action plan for a football field may be different from your emergency action plan for tennis courts or swimming pools. First court case I'd like to discuss is Ray versus Chelsea School District in Swagger. This was an incident that occurred to a cross-country athlete, a high school cross-country athlete, who was struck by a vehicle during a 6 a.m. cross-country practice that occurred off campus. This produced a neurological traumatic brain injury in the student athlete, rendering them in a coma for 10 days. Following discharge from the hospital, the athlete did sustain partial paralysis and are not ambulatory. Eric Swagger was the coach at the time that elected to conduct the practice at 6 a.m., which was a huge incident that was frequently cited in the case, was the issue of low visibility. Initially, Eric Swagger made mention and alleged that they weren't directly responsible because they weren't the one that hit the student athlete. However, the courts, while he wasn't directly responsible or the direct cause of Kirsch Ray's injuries, they did cite him for proximate cause for conducting the practice so early in the morning at a time in which there was such low visibility, which they ruled in favor of Ray, and the settlement arriving at a settlement of $4.5 million. Risk mitigation for something like this, of course, the NATA does recommend attempts to decrease or limit medical response time. There's always a risk of that when you have athletes training off campus. If they are training off campus, I think it's vitally important that the athletes while training off campus, are close to campus. Additionally, improving clinician and student-athlete ratio. This did occur in the secondary school setting, and that's a common issue within that setting, in that usually there's one athletic trainer employed at a school for 800 plus student athletes, and this forces the athletic trainer to have to determine or decide which team will be able to have their direct attention at that point in time. So if you have multiple games going on at multiple venues and you only have one athletic trainer, it may very well end up that only one team is going to have direct access to that athletic trainer at a certain point in time. Further, CIF does require that all coaches, California Scholastic Federation does require that all coaches are CPR and AED certified. I would certainly ensure, as an athletic trainer, while the athletic director does oversee this typically, as an athletic trainer, I can have a hand in this, ensuring that all the coaches are up to date on their requirements by our governing body, which is to be able to render CPR and administer an AED. Another thing that can mitigate risk is supplying off-campus teams with the supplies needed, like an emergency or a first aid kit or something like that. I think it's critically important, especially when you have athletes training off campus. Plevrides versus LaSalle, this is a really interesting case. This was a case of a college football player who suffered a head-to-head collision during practice, resulting in a concussion. They did have symptoms that they reported to their athletic trainer, who referred them to the student health center, in which they were received by a nurse who diagnosed Plevrides with a concussion. However, shortly after the diagnosis, 2 days later, they were released for return to play. Despite still being symptomatic, 1 month later, Plevrides sustained a brain injury during a game where he tackled a punt returner. And during that collision, he was rendered unconscious and convulsing on the floor. So they rushed him to a hospital nearby and performed emergency surgery to do decompression surgery to remove a blood clot that was producing that pressure. They were eventually discharged from the hospital. However, unfortunately, Plevrides does suffer lifelong neurocognitive disabilities and physical impairment as a result of his injury and will require lifelong care. The ruling, of course, in this situation, there was inappropriate referral and immense oversight by the athletic training staff, and the court ruled in Plevrides' favor, and they settled for $7.5 million. A situation like this is very unfortunate, and I believe was entirely preventable. Risk mitigation for something like this, of course, is adhering to your governing bodies. That would include the NCAA in this instance because that's a collegiate setting, but also referencing other governing bodies like the NETA, which does release position statements, and it does maintain updated position statements on recommendations for the management of injuries like plevritis sustained, such as concussions. All of the data, all of the stuff as far as NETA, the NCAA, they're very explicit in requiring physician evaluation and clearance, which was not conducted in this event at all. Unfortunately, the athlete was very, very, very inappropriately referred to underqualified medical staff, which made the return to play clearance, which led to this athlete's premature return to play. So really important as far as risk mitigation, reference your materials, reference the governing bodies that are providing the professional standards of practice for certain types of pathologies or injuries. Also, adhere to those standards of practices and adhere to those professional guidelines. That would have been critically important in preventing something like this happening. The third one is Rios versus Grossmont Union High School, which is a very unique case. It was a high school athlete who suffered an ankle injury, a very mild one albeit, but when they came off the sideline to be evaluated, the head athletic trainer was not present at that point in time, and so they were received by a student athletic trainer who was doing their clinical undergrad of observation hours, who went ahead and evaluated the ankle, they taped it, and then they cleared the athlete for return to play. Unfortunately, shortly following that athlete's return to play, they sustained a compression injury which resulted in 2 cervical fractures in their neck and damage to the spinal cord. Uniquely, in this specific case, the court did not rule in favor of Rios. And in fact, they found that the Grossmont Union High School District was not liable. The reason being, though, in something like this, is when you talk about risk mitigation, the way they approached it, had they approached it possibly differently, it could have been a different situation. CATIE is the Committee on Accreditation of Athletic Training Education, and they strictly require that all student athletic trainers are under the direct supervision of a preceptor. In this event, the preceptor was not available. The head athletic trainer was not on site during this game, but the athletic training student was, which would have been a violation of CATIE's Standard 63, which requires that all student athletic trainers are under the supervision of their preceptor at all times. Again, an issue of improving clinician-student-athlete ratio. The athletic trainer was not off campus, but they were not sidelined. And of course, enhancing communication efforts would have obviously, it's hard to determine if that would have changed the outcome. This was kind of a freak accident, but they did find that the student athletic trainer was not the direct cause of the injury, and nor was the head athletic trainer not being present. But had they approached it differently from maybe a CATIE violation, the outcomes could have been completely different as far as the court rulings. Employment law mostly has to do with hiring and termination, equal pay, and issues of discrimination. The first one is Berkey versus Marshall County Board of Education. The plaintiff was Linda Berkey, who was suing the Marshall County Board of Education for unequal wages. She had developed she was tasked with forming a girls basketball program, which later went on to win 31 games in a season. At this point in time, female coaches were not paid like their male counterparts, and so she penned a letter to the superintendent, Donald Haskins, regarding concerns for unequal pay, to which she did not make any efforts to amend or even consider her concerns. So she filed a grievance citing discrimination based on gender. And the following year, she filed charge, which was extended to the Equal Employment Opportunity Commission and was later awarded jurisdiction on that. Unfortunately, following the award of jurisdiction, Berkey was then transferred from her original school to another school. So following the transfer, she went ahead and filed another charge for retaliation, in addition to filing suit for not being allowed to coach boys' sports. The findings in this court case was that the County Board of Education was in fact in violation of Title VII for unequal wages and discrimination, and the ruling was actually settled out of court in this instance, but back pay was included. Risk mitigation for this, of course, strict adherence to Title VII of the Civil Rights Act. That is something that is so vitally important to promoting the just overall disposition and nature of especially administrative staff and coaching. Really, really critically important, equal pay, and adhering to it strictly. Of course, providing safeguards against forgiving not employment practices but unequal employment practices, and then making efforts to avoid homologous reproduction. In other words, you want to make efforts to avoid individuals. There's a tendency for individuals to hire those that are very similar to themselves. We want to kind of promote diversity within our community. Moore versus the University of Notre Dame. Joseph R. Moore was a coach at the University of Notre Dame who was fired for their inability to comply and get along with administrative staff, their direct supervisor, as well as verbal and physical abuse of football players. So Moore went ahead and filed suit claiming discrimination, unlawful retaliation, and defamation. Though the university did offer to pay for liquidated damages, Moore declined, preferring to be reinstated as a coach or be awarded 5 years of front pay. The school denied that, and so in order to get that front pay, Moore had to demonstrate evidence of not being able to attain comparable employment, which he did, because following his termination, he actually took on 3 jobs, and despite that, was making 50% less of his earnings. Therefore, he was able to demonstrate evidence of not being able to attain comparable employment, and actually in the ruling of this situation, the courts agreed with the University of Notre Dame and did not reinstate him as a coach. However, because he was able to demonstrate evidence of not being able to attain comparable employment, they did grant front pay and expenses. So that was a kind of a unique situation. For something like this, risk mitigation, I think documentation of interaction between coaching staff and athletes are vitally important, as well as coaching staff and administrative staff. Again, we have to ensure that we're enforcing student-athlete protection and accountability by not just the head coach, but also throughout administrative staff and all of coaching staff, making sure that we're keeping our athletes protected and documenting anything that we see that is inappropriate. Purdue versus New York City. This was Molly Purdue, who was a basketball coach for a women's basketball program at Brooklyn College, and she sued for unequal pay violations, discrimination, and sexual harassment. She was able to prove that she had the same similarities as her male counterpart, the male basketball coaches. In addition to being a basketball coach, just like the male basketball coaches, she had additional responsibilities acting as a women's sports administrator. And the ruling actually found that the university had participated in prohibited practices, which included sexual harassment in a hostile work environment, and was also in violation of the Equal Pay Act. She was able to demonstrate that she had similar responsibilities as him, in addition to additional responsibilities, that she should be paid fairly. And she was able to prove that, and so the ruling was in her favor. As far as application, always act in accordance with the highest professional standards at all times. Maintain adherence to the scope of practice, vitally, vitally important for healthcare providers. I did not find a lot of research and data on employment issues with athletic trainers, but when there was litigation involved within athletic training and with most healthcare, it was issues of risk management. Also, commitment to lifelong learning. Keep yourself up to date on the latest, greatest practices and protocols. Check in with your governing bodies. This class has really profoundly changed the way I approach my practice, and I think it's fantastic. It's had a very positive impact on me. Always emergency action planning. You know, we say hope for the best, but prepare for the worst. And then development of policies and procedures. Tailor your policies and procedures. And practice those. As far as emergency procedures, practice them with coaching staff. Involve your coaching staff and things like that. So I definitely want to take what I've learned in this class and apply it most certainly to my everyday practice as an athletic trainer. As far as faith and integration, a couple things that I think really stuck out to me, and a lot of them was the first one is talking about doing your best to present yourself to God as one approved as a worker who does not need to be ashamed and who correctly handles the word of truth. Present yourself in the best manner. At all times. For the next one, where it talks that there's neither a Jew nor Gentile, neither slave nor free, nor is there male or female. I think this really speaks to as far as equality within the workplace and employment. We're all the same. We're all, children of God. I think it's really important that we remember that and that we encourage diversity, because though we may be different, we're still His children. And of course, I think with litigation, with law, it's really important that it says do not spread false reports, do not help a guilty person by being a malicious witness, be honest and truthful in everything that you do. And lastly, I want to talk as far as conflicts, personal conflicts with professional setting and your beliefs. I think it's critically important that you align yourself and you surround yourself with like-minded people. And if you are in a situation where their beliefs don't align with yours, I think the best thing you can do, while it's important to always adhere to the law, it's also important to surround yourself with people that share similar values as you. And I think that's the most important. So thank you very much.